Hi, I'm Carl Conrad and welcome to Australian Immigration News, proudly brought to you by Australian Immigration Law Services here in Sydney. The big change in migration law this week was that New Zealanders who gain their permanent residency using the 189 visa will be allowed to apply for citizenship immediately without waiting for the usual 12-month requirement. This change is in line with the announcement made late last year in relation to the benefits New Zealanders will gain by living in Australia. Now that the 189 visa is closed to New Zealanders, it is expected an even easier pathway to citizenship will be announced without perhaps the need to go through the permanent residency pathway first. New Zealanders will be in an enviable position indeed if and when that happens. Concerns have been raised by many 491 visa applicants since the end of last year because the Immigration Department's processing times website was updated to show 90% of applications are expected to be finalised in about 30 months. A big thanks to Christine, who wrote in on our comments page to alert us to this dramatic change from the previous 9 months to the current 30 months. This is a huge jump and there is no reason indicated for this enormous change. However, it should be noted that as the backlog of applications are finalised, this will have a significant statistical impact upon processing times in the coming months. It is possible we may see similar large swings occurring which may not be a true reflection of what is actually happening. I'm confident that it will not take 30 months for 491 visas to be granted. Also, the figures of the 489 visas where 90% are processed in 48 months and the 300 visa where 90% are processed in the next 38 months should also improve. Let's see what happens over the next couple of months before we all get depressed. The Australian newspaper reported that we are predicted to be short of 1 million people by 2030. That was forecasted prior to the COVID-19 pandemic. However, international students have been found to lead the surge whereby net overseas migration is forecast to reach the pre-pandemic trend of 235,000 people and continue to remain at this rate thereafter. Perhaps the international students will soon be overtaken by New Zealanders flooding into Australia when they realise how easy it is to gain Australian citizenship here. I predict the New Zealand government won't be so happy when the brain and skills drain to Australia will start to have a serious impact upon their economy. The India and Australia Free Trade Agreement came into force on Thursday, offering many benefits to businesses in both countries. I've been asked a few times recently on when will India be added to the work and holiday eligible passport holders so they can apply. Well, first remember there's only going to be 1,000 lucky young people who will have this privilege. And secondly, they did say in the original announcement that it will happen within the next 2 years, so don't hold your breath. The rumours circulating regarding the validity of the professional year programs has now reached the ridiculous level, so it's time that we take a quick look at this issue. People are worried about lodging their applications and not being able to gain the 5 points they claim. Let's examine the most important information available: the current policy documents, the department's website, and the department's actual application forms. Firstly, this is the official policy documentation published by the Immigration Department and can be publicly obtained. This reproduction seen here is the only reference regarding the timeframes and the PYP claiming of the points. Applicants are eligible for 5 points only if they have, in the relevant period, completed a PY. We'll leave a full description of the policy in the description below in this video. Now we know what the relevant period is. It is the 4 years before the invitation to apply is received. The government's own expression of interest form, the EOI, and on all the points-based visa application forms asks the same following questions. Has the applicant completed a professional year in Australia in the last 48 months? On the Immigration Department's website, in relation to the points table system, it has the following information. At the time of invitation to apply, you had completed a professional year and completed in Australia in the 4 years before you are invited to apply for a visa. visa. Now, there are other important things to consider also. PYP providers do not provide completion letters, only graduation certificates, and these certificates only state the date of completion. In all of the thousands of applications we have lodged since the PY programs began back in 2008, the Immigration Department has never asked for evidence of a starting date. In 2008, PY programs were allocated 10 points in the GSM visa system. Most programs ran for 44 weeks, and in some cases they were even completed fast track in about 6 months. In 2011, PY programs were allocated down to only 5 points in the GSM point system. Also in 2011, the law was altered to mandate PY programs were to be 12 months of duration to make them equivalent to the status of Australian work experience points. However, after 2011, most providers kept their courses at 44 weeks of duration. The Immigration Department turned a blind eye to the fact that nearly all of the PY programs did not run for 12 months and thus did not ask applicants to provide completion letters regarding course duration. Now, we are aware of this advice sent out by the GSM program management team of the Immigration Department, which states professional years must have been commenced and completed in the 48 months immediately before the time of invitation. Now, is this advice from the department available to the public? No, it is not. Similar versions of this advice has been floating around to migration agents for more than 6 months now, and still there is nothing in official policy documents that confirms its validity. And what will happen if the Immigration Department actually tries to enforce this type of approach? Well, then they will have to ask PY providers to hand over completion letters confirming the start date and the completion date of their courses. And what do you think will happen when these letters clearly indicate that these 44-week courses that have been running for over a decade now do not meet the legislative 12-month requirement as stipulated in 2011? I can't even imagine the potential ramifications of that. It will bring into question the Immigration Department's running of the GSM program and what role the PY providers had in providing courses that were technically short of the legislative requirements. It's a can of worms that I do not believe for a second that the Immigration Department really wants to open. And in summary, agents and lawyers should not be directing applicants not to lodge applications based upon emails that are not supported by official policy documents. If you have decided to not apply because of this issue, and you may miss out on being able to apply for your visa, you may want to think again about that decision. And on that note, I would like to give a big thank you to all of you who have made appointments to see me regarding their immigration inquiries to Australia. It has been a great pleasure and an honour to speak with all of you. A special shout out to Carla and Kim, a lovely couple I chatted recently with, and our loyal followers to our channel. And remember, we are here to provide assistance should you need it. Don't forget to subscribe and be sure to get the latest updates, as we expect many changes will be coming this year. So as always, take care out there, and I'll see you next time. So bye for now.